This is Xcina Consulting, working in partnership with the London Digital Security Centre. This podcast forms part of the LDSC April theme, Managing a Breach. Speaking on today's podcast is Mark Child, Executive Managing Director of Xcina Consulting. Welcome along, Mark. In your opinion, could GDPR become the new PPI? Could it create a wave of no-win, no-fee compensation claims against non-compliant companies?
Hi Sarah, and what a great question to start with. Anyone who has visited or attended one of our seminars or presentations over the last 2 years will tell you that this is something that we've been making people aware of for some time. The reality is, in the US and Europe, these particular examples are well documented and very prevalent. It is not unusual for class actions to be brought against organisations in those countries. The reality is, if you think it's not going to happen in the UK, think again. What I would say to organisations is, as a minimum, what you need to do above and beyond all things is ensure that you are GDPR ready and have yourself in a defensible position for when the regulator comes along.
Okay, so what do you think are the most common breaches that SMEs face in today's digital climate?
The reality is that most breaches are relatively straightforward. They're not things of the dark web, etc. They are fundamental failings within organisations' control environments, and invariably down to people rather than systems. Unfortunately, most commonplace in terms of what we see as an organisation is organisations simply don't understand where their data resides. Some people call this data mapping, and the reality is you need to understand where all your data in your organisation is, both from a physical, i.e. information that you keep in cupboards and drawers under your desks, and a logical position, i.e. that information that you keep on your network and your servers. You also need to ensure that it's appropriately classified. If you do so, then you'll be able to manage that information in accordance with its risk. In terms of most breaches, they tend to be down to maybe a disgruntled employee, a lack of training and awareness in terms of making your staff aware of what their responsibilities are. Certainly in today's cyber society, people are familiar with phishing attacks and advanced persistent malware that resides on the system and steals that data from within and communicates it out. And to that extent, there are some basic security measures you can put in place. Things like antivirus, firewalls, having an organisation come and perform a penetration test on you, etc.
So what happens then if a company has had a data security breach? What can they do to manage it? And does any member of staff have any responsibility in particular?
In terms of if an organisation has a data breach, the rules are changing. The Information Commissioner's Office must be notified within 72 hours of an organisation becoming aware of a breach. Where an organisation cannot provide notification within 72 hours, an explanation of the reasons for the delay should accompany the notification, and information must be provided in phases without any further delay. The notification must at least describe the nature of the breach. It must also communicate the name and contact details of the data protection officer or another contact point where more information can be obtained.
So if the company doesn't have a data protection officer, can someone have a dual responsibility, or how does that work?
Okay, it is not a mandatory requirement under GDPR for an organisation to have a data protection officer, unless it is an organisation, for example, a hospital, whereby their sole processing activity is largely personal data. But what you have to have is someone who has that appointed responsibility within your organisation. So it can be a dual role. What I would say is the role is now becoming more and more complex, and as a result of that, please don't underestimate how long it will take you to fulfil that role and all of the duties associated with it. You will also start to hear the phrase virtual data protection officer, and what that means is you can actually now go and outsource that responsibility, and there are many organisations who will provide those data protection services for you.
Okay, so if the company or a company has had a data security breach, what immediate follow-up should it do?
In terms of if you have a data breach, the first thing I would suggest you do is ensure that you actually do have a breach. We see a lot of organisations take inappropriate action in terms of breaches when actually they don't need to have taken any action at all. The reality is, as I say, first things first, confirm that you actually have had a breach. Secondly, you really need to start preparing now. And the amount of organisations that we see who fail to undertake any exercises, for example, in terms of breach management, breach notification, etc., is incredible. Practice makes perfect in these instances, and therefore I would suggest that all organisations, no matter how small, practice at least once a year a data breach scenario. Of course, there are organisations who can help and support that for you, but the reality is they're not beyond the realms of man in terms of the level of detail you need to go into.
Okay, so what sort of fines are we talking about?
This is where it gets interesting and also gets very painful. Underneath the Information Commissioner's Office, the old fining regime would levy a fine of up to £500,000. Under GDPR, there is a significant increase, and it is now up to €20 million or 4% of annual global turnover. So that is an extortionate amount of money in terms of what you are now going to be seeing potentially in the fining regime. The reality is that those fines are going to be representative of the seriousness of the breach and the nature of the breach. Will they come into force immediately? The answer is yes. The reality is, do I expect there to be multi-million fines levied from day one? Probably not, but in due course there will be.
So if a company is fined, is it down to the data breach itself, or is it bigger companies will get bigger fines?
I think it's fair to say in the past larger companies have received larger fines, but I think the reality is moving forward that the fine will be representative of the nature and seriousness of the breach. And as such, it won't matter if your company is small, medium or large, the fine will be representative of the damage that is done in respect of exposing that individual's personal or sensitive data. I think it's safe to say that there are a lot of organisations out there who think GDPR doesn't apply to them, and or they think they're going to get away with it. But rest assured, it is coming into force on the 25th of May 2018, and no matter what your size of business, you're going to have to comply with the law, and you're going to have to comply with all facets of the law.
What kind of controls should an SME consider putting into place to stop them having a breach in the first place?
Okay, so we discussed earlier about some real basics, and of course the first one is to make sure that you know where all your data is and what data you actually have. The only way really to do that is to map that data. You don't need a technical know how to do that. You can use tools such as Visio and even Excel to plot and manage your data. You also need to classify your data, so you need to determine how important data is, what it means to your organisation and what it means to the individual. The other reality is make sure that you don't overlook staff training and awareness. It's very common for organisations to fail by not providing all of their staff just basic training and awareness, which is a mandatory requirement under GDPR. Also take a look at your third parties. Third parties who process data on your behalf are now also culpable under GDPR. So you as the controller, as it is known, and they as the processor will be likely to receive fines of an equivalent nature for breaches. We find that most organisations have simply failed to check their third parties and the controls that their third parties have in place. Also, you might want to consider penetration testing, vulnerability analysis, etc. And also, please don't overlook some basics like CCTV there is a whole set of guidance around CCTV, and again we see a lot of breaches occur as a result of poor management of CCTV. Please don't underestimate CRM systems. Most CRM systems we look at aren't GDPR ready, and certainly if you could be GDPR compliant at the moment, they certainly aren't that. And also look as to what organisations you work with and whether their location overseas, wherever that may be. There is something called cross-border transfers, and just because an organisation is outside of the European Union doesn't mean they're void of their general data protection responsibilities. So lots of things to consider and lots of controls to consider as well.
Yes, there's a huge amount to consider, like you've said. Well, that's all we've got time for today, Mark. So thank you very much indeed for your time. It's been hugely insightful, and I wish you a really good day.
Thank you, Sarah. And as always, we're here to help. Xcina Consulting, if you're stuck, please give us a call. There's lots of information on our website that's downloadable free of charge. We can certainly point you in the right direction, and also look at the LDSC as well. Their website is particularly helpful, and there's lots of people on there who are willing to provide you with support and assistance as where required. Thank you very much, everybody, for listening.
Thank you. Bye-bye.